Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about what it means public charge and what a public charge is. It actually comes up quite often, and a lot of times people can't come into the United States or they can't properly adjust because they can't get over the public charge hurdle. Now, if you've seen any of my videos, of which there's a lot, I have lots of videos on what makes somebody inadmissible. So there's lots of videos on different kinds of crimes, on fraud and misrepresentation, on medical issues, things like that. But what people don't realize is being a public charge, from admissibility point of view, is the same. That means that if you are considered to be a public charge, you are inadmissible to the United States and you're not coming in. Okay? So, while you may have a completely clean record and you may never have committed any fraud or misrepresentation and you might be the healthiest person in the world, if you are considered a public charge, you're inadmissible. So, first, what does public charge mean? Okay? Public charge is essentially when the United States believes that if you come in, that at least for the next 10 years or until you become a U.S. citizen, that you will have to use governmental resources, for example, for your medical needs, for education needs, for things that you do not have sufficient funds to pay for yourself. And there's a calculation that they use to determine this. And it's really not what you make. It is what your sponsor or petitioner makes. So let's just say, you're the spouse, and you are coming into the United States through a marriage petition. Okay, so procedurally, what happens first is your spouse, let's just say your husband, um, has to make a certain amount of money so that you won't be considered a public charge. Again, it's not really what you make, although there's ways of working that out, but for all intents and purposes, it's not what you make, it is what your spouse makes, the U.S. citizen or lawful permanent resident spouse. And the way they determine it is there is a poverty guideline chart, okay? And that poverty guideline chart has what the amount is that the U.S. government says is at the poverty line for the number of dependents in the family. So, for example, if there's only two people, you're looking at about 21,000 per year. If there's three people, it goes up to like 24,000 and so forth. So the more people that are dependent in the family, the higher it has to be. Now then, you take 125% of that. Okay, so if let's say that the poverty guideline for two people, let's just say it's $18,000, you take 125% of that, which would be close to 20,000, right, somewhere in that neighborhood, and that is the amount of income that the spouse has to have, and that is on the prior year's tax return. So, as part of what needs to be submitted, the submits the prior year's tax return. And let's say we're talking now. Okay, let's say that we're talking in August of 2015, and so you show the taxes that were filed and what was made in 2014, and if that is sufficient, then you have nothing to worry about and no need to watch any more of this video. But if, as in many cases, that's not sufficient, then there are ways to get around it. So let's say that the husband, the U.S. citizen husband, only makes $17,000 a year. Let's say he's just got out of school or he's in school, okay, and just working at a part-time job just to make ends meet a little bit while he's going to school, so he doesn't have the necessary income. So what do we do? Well, the first thing is to try to find a joint sponsor. Okay, now a joint sponsor doesn't have to be related to the petitioner or beneficiary, but the sponsor has to be either a U.S. citizen or lawful permanent resident and has to be domiciled in the U.S. So if let's say that your uh, uh, friend who is going to sponsor you is a U.S. citizen, but that U.S. citizen decided to move to France, 15 years ago and hasn't been back to the U.S. since, well, that's not going to work. Okay, for all intents and purposes, they need to be living in the U.S. at the time that they're going to be a joint sponsor, and then what happens is they have to make the requisite amount of money and they sign the joint affidavit of support. And what that means is that if the beneficiary, which is the person coming in the U.S., goes on certain government assistance uh, for the next 10 years, or until that person becomes a U.S. citizen, essentially it's a contractual requirement between the joint sponsor and the government. The government can come and get reimbursement for that money from the joint sponsor. Okay. Now, one thing I want to make clear is, let's say, in an example, let's say just for rounding sake, that we have to show 20,000. Okay. And let's say that the husband makes 15,000. So a lot of people think, well, you go find a joint sponsor. Joint sponsor only has to make more than 5,000, and boom, you've got it satisfied. It doesn't work like that. The joint sponsor needs to make the entire amount that is necessary in order to go forward. Okay, and if the joint sponsor is properly found and all the documents are submitted, then theoretically the USC husband, in our example, doesn't have to make a penny. Still has to submit the affidavit of support. Still has to, sign everything showing he doesn't make anything, basically. But the burden then would be on the person who's the joint affiant. And the reality is, especially on a marriage petition, is that the beneficiary is going to come in and most likely become a U.S. citizen within 3 years. So remember, as long as the beneficiary becomes a U.S. citizen, the obligation disappears. Now let's go to the next scenario, and that's where, in our example, husband doesn't make enough money, can't find a joint sponsor. They either don't know anybody that'll help them, they have no family, and the people they do know don't make enough. What do you do? Well, you can go to see if they own sufficient assets. So let's say that the husband owns a house and it's worth, a considerable amount of money, but doesn't make sufficient income for whatever reason. If the assets that are owned are 5 times the amount that is needed in which to proceed forward, then that can substitute in for the lack of income requirement. So again, if you own, if you need 20,000 and you can show that you have about 100,000 on the house, then that's another way to go forward. Now the reality is they put that requirement in there, but a lot of people, if they don't have sufficient money to show or meet the minimum requirements, they're not going to own the assets to show that they do either. So what do we do? Well, the next step is there are legal arguments we can make to show that the petitioner is going to make sufficient money, and the petitioner is going to show that the beneficiary won't become a public charge. So that's where we use the totality of circumstances arguments. And I've had cases where they just got a good paying job, or they basically had an interview and they're going to get a good paying job. And there are ways of submitting notarized affidavits from the employer that they're going to make sufficient money. There are ways of showing why they didn't make it up until the present time and why they're going to make it at this time. There's ways of showing all kinds of, through little bits and pieces and a totality of all the circumstances, that the person won't become a public charge. And so, as you can see, there are several different manners in which to attack this particular issue and get over it without having to just give up and not come in the U.S. because the petitioner doesn't make enough money. Okay, so if you like the video, click like, click subscribe, and feel free to give my office a call and or email me. The initial consultation is free. More videos in the coming weeks. Thank you.